Hey guys, Gossiping Reactions Moristic. My parents are spending my inheritance. What can I do about it? I'll tell you what you can do. Nothing. They work hard for their money. You would have to work hard for your money to save money for yourself and your kids to come. You cannot expect your parents to live a low life, leaving everything to you. Watching the topic of inheritance with parents might be daunting because even the most diplomatic approach could appear to be self interested. Nevertheless, planning for the future is essential to maximize prosperity for younger generations and minimize inheritance tax bills. In Britain, adults' children have no automatic right to their parents' money. Oh, really? However, most parents do want to preserve their capital for their children and grandchildren while still having enough to enjoy their retirements. Okay? This is particularly important when second marriages and second families can complicate matters or when adult children may need to take on power of attorney on older parents' behalf. Telegraph Money explores the best ways to manage multi-generational finances while still allowing for retirement cruise trips and well-deserved luxuries for parents. How to speak to family members about money. It's a difficult subject, trust me. Involving the whole family in planning can help to reduce the potential for future disputes and manage expectations, says Sean McCann, a chartered financial planner at NFU Mutual, the insurer. Plan as early as possible, as the earlier you plan, the more options you have, particularly when it comes to mitigating any inheritance tax bills, he says. Involving a solicitor or financial advisor, experience in helping families to plan can open up options that may not have been considered. It can also help to remove some of the emotion from discussion if someone from outside the family is involved. Being fair to all children does not necessarily mean promising equal shares of wealth. As Elena Morrissey, the city superwoman, has described for her own family of 9 children. Woo! There was no simple formula, just some pointers to help make the best of things and importantly prevent arguments or resentment between family members. She wrote for Telegraph Money. Avoiding misunderstanding will be easier if everyone communicates openly, but giving and receiving money can feel awkward. McCann says parents may want to reflect any financial help they've given to certain children during their lifetime, or the fact that, for example, one child may have invested more time and energy in a family business. Setting up power of attorney. A lasting power of attorney is legal documents that enables one or more people known as attorneys to make decisions for or act on behalf of an individual who cannot make decisions for him or herself, the donor. There are 2 types of LPA. One relates to health and welfare, the other to property and financial affairs. At the time an attorney is appointed, the donor must be 18 or over and have mental capacity. A property and financial affairs LPA allows the attorney to make decisions about managing money and property, including selling a home or managing a bank account. Louise of the law firm Fitz says families should start to consider power of attorney at any times after the age of 18. We recommend that people do them as part of their general estate planning. For example, at the same time as doing their will, she says. how to protect family money if the parent refuses to attend a medical appointment. According to Lewis, this is a tricky situation. While people have capacity, they can make universe unwise decision. This is enriched in the Mental Capacity Act 2005. She says, if adult children have concerns about their parents, they should seek advice from social services, which have legal responsibility under the CARE Act 2014 for anyone with eligible needs. If necessary, social services can refer the individual for medical treatment with the NHS and involve doctors. In certain circumstances, they can force someone to be sectioned to undergo treatment. As social services tend to be very busy, it is best to make a referral sooner rather than later, Lewis says. When can power of attorney be abused and how do lawyers guard against it? For professionals who make best interest decisions, particularly with potentially vulnerable clients, the Mental Capacity Act 2005 offers legal guidance. Lawyers may use a vulnerable client policy to support individuals. As an example, Lewis says, a client with a cognitive impairment may need conversation to be recorded, longer meetings, and the use of notes to review any suggestions made. Can an attorney be blocked by the donor from making a decision under a power of attorney? This happens often, says Lewis. Capacity is specific to the decision concerned. So someone may have capacity to do some things but not others, she says. Often someone may have the capacity to make their own welfare decisions but not to manage their affairs. In this situation, you may wish to seek legal advice. The story keep on going, guys. I don't know if you want me to finish the whole thing. It's a lot. Managing money with second families and remarriage. Lawyers and financial planners cannot ensure that adult children inherit their parents' money because adult children have no automatic right to an inheritance in Britain, unlikely in France, for example. If a parent has remarried and had further children to whom they bequeath the estate legally, it would be difficult for the adult child to challenge it. However, situations do arise in which adult children may have been informally promised money. They may raise this as a claim against a parent's estate. It is really common to have mediation after death to settle such claims. Lewis says, in Britain, individuals are free to dispose of their estate as they see it fit. However, the courts do have a limited power to intervene under the Inheritance Act of 1975 if there is judged to be a failure to make reasonable financial provision for a certain number of people linked to the deceased. These include the spouse or civil partner or child. Claim must be made within 6 months of the date of a grant of probate or letters of administration and give full disclosure of financial needs and resources. A trust may be the solution. If parents put money in a trust, adult children can rest assured that their inheritance is protected and parents can enjoy spending in retirement without touching the money set aside for future generations. McCann says it is a common misconception that trusts are just for the wealthy, and the most simple form trust can be used with life insurance policies to ensure that they don't form part of your estate for inheritance tax purposes and to speed up payments to your beneficiaries by avoiding having to wait for probate, he says. They can also offer inheritance tax advantages if you give assets to a trust and survive 7 years. The value will normally fall outside your estate. Again, when I saw the article, I thought the kids were crying because, hey, you're spending my money because now you're retired. If you're no longer with us, are you going to leave me anything? But then it went into some deep details. It's more than just spending money. Again, if you want to know more about this article, it's about Yahoo News. Go on Yahoo News and get more information. Subscribe and let me know how you feel. Bye.